Good afternoon, everyone. Welcome to the event. First of all, I'd like to thank the Honorable Chief Justice Dr. Sheel Nagu and all the Honorable Judges for allowing us to use this historic space to conduct this seminar workshop on crafting litigation with BNS. And I would like to extend the welcome to the panelists. Amrita Garg, she is the Assistant Advocate General Punjab. Mr. Gaurav Datta, he's been on the bench and on the bar. He served as a JMFC. And former DAG, Mr. Arjun Sharon, now he's a criminal lawyer. Welcome, everyone. So today's topic is BNS and the changes that have been brought about by the new implementation and the changes in the erstwhile IPC. So I'd open the floor. The topics are with you guys. And let's start with Mr. Arjun, sir.
Thank you, everyone, and thank you, Suvir, and the entire team which has organized this wonderful event. And this is truly historic, the fact that young lawyers, intellectuals of this community have come up here, and this is being recorded for posterity also. A lot of people across India will be viewing this, so I am very happy and honored that I've been called for this. Now, starting with the topic, let's get the brass tacks down. First, that the IPC was in itself a new thing in the world, right? It comes in the 1860s, takes 25 years in the making, and it is India is one of the first British colonies where the IPC came in as an experiment. So this was not a system which existed in UK. This was something new. It had its relevance for the next 150 years, and you see that even today about 90 to 95% of BNS or the other sections or the other criminal statutes retain the same flavor. Now let's go to what are the broad changes. As a student of law, most things would remain the same, but many things have also changed. There are about 30 odd offenses where there is a mandatory minimum. So offenses like 307 and others, where now they say minimum 5 years sentence has to be given. So that judicial discretion has been taken away. There were about 30, 40 odd sections where the fines were rupees 100, 50, so on and so forth. With time, those have been increased to 5,000, 10,000 odd. I have my own view about it. It should have been increased much more so that the punishment element increases. The third is there were several sections which were no longer relevant. For example, section 311 regarding thuggery was not relevant. After the Joseph Shine judgment, we didn't need the section on adultery, and so on and so forth. 309, attempt to suicide, all gone. So all these sections have been taken off. So there's an entire list of about 30 or about 50 sections which have either been modified or completely been removed. And I would request you all to download the BPRD or the NCRB. These are both Government of India organization. They've come up with an app which shows the differences and the inclusions in the BNS vis-a-vis the IPC. The fourth category is also very interesting. The fourth category are new crimes. And some of these crimes are borrowed crimes. They've been taken from other statutes. Some of these crimes are new inclusions. I'll give you a few examples. There is the offense of organized crime, which used to be there in Makoka and Gakoka. That's the Gujarat Control of Organized Crime Act and similar act in Makoka in Maharashtra. Both were supposed to be very stringent act against smugglers and all sorts of anti-national elements. And they used to also have certain provisions, like, for example, in Makoka, to even initiate a prosecution, you need the DGP's sanction, for example. Phone tapping could have been used in that. Even if you're giving some evidence before a police officer, that could have been used as part of the evidence. So there were many things. The burden of proof had been reversed. What the BNS has done is only taken the definition of organized crime, almost 99% of it is the same, and put it there at section 113 of the BNS now.
111 and 112.
Yes. The second thing they have done is also added something called petty organized crime. So this is the second section. Then they've added one section 69, which is false promise to marry on the basis of certain things not amounting to rape, because earlier most of these used to be amounting to rape. That has been done away with. And if you make any promise or inducement, etc., or any promise or inducements are made, then in those circumstances, you can be prosecuted. This is especially useful in many circumstances where there is a power dynamic between the parties, and we've seen many of those cases. At the same time, many people have said that there is a possibility that these offenses could be misused. And broadly, BNS has been rationalized. Like, for example, if cheating is an offense, earlier it used to be covered in 5 or 6 different sections. Now they've all put them down in subsections. So it's an interesting exercise. It is not a perfect exercise. There are criticisms also, but we have a new, a fresh slate, a fresh start, where all of us can debate, and hopefully the government will listen, we can make those changes also. So it's been a good journey overall till now.
One question that pops up over here is, you've spoken about the acts such as Makoka, UAPA that existed.
Yes.
Terrorism was being tried under those acts.
Yes.
There were some provisions which safeguarded the prosecution
Yes.
as well. Now, what was the need to bring the organized crime and terrorism under section 111 or 112 of the BNS? Does it make the prosecution easier? Does it make the how does it help the accused vis-a-vis the state agency?
I don't think it helps the accused, to be very frank. It will help the state, because if you see Makoka and Gakoka, it took them 30, 40 years to get these acts passed in their respective states, because the president had to give assent. Even I think even Haryana wanted Hakoka Act, Madhya Pradesh wanted one, and many other states tried to get these, but since each act had to go, president had to prove, plus each act had a sanctioning provision, each act had a reverse burden of proof, and generally these acts were also, some people called them draconian. So they were anti the accused, because if you give a confession to a police officer, that would be counted. So, but now what this has done is, across the country, the same organized crime section will become a crime, and the ordinary rules of criminal procedures will apply. The good thing about that is that the elements which are, or the organized crime elements whom you want to target, they can be targeted very well. But some unscrupulous elements within the authorities, police officers, etc., could misuse the wide interpretation. For example, if you look at section on organized crime, assisting or abetting some organized crime can easily be put on anyone. And what do you do in those circumstances? Second, the definition, I believe under section 15 of UAPA, of terrorism was already very wide. One of the examples we used to give in court while arguing UAPA cases was that if Punjab University students are protesting something and they burn a board, tomorrow the police technically can say you have burned a public property using an inflammable material to overawe the government, and this is terrorism. Now that section of UAPA where you required sanction from the central government or the state government, you also had, of course, stringent bail provisions. You also had the prohibition of 438, anticipatory bail. They have all that goes. Instead, you have a plain vanilla provision of terrorism. And now the discretion, I believe, is with the DSP or SP, has been given the discretion of whether to apply UAPA or to apply terrorism. And I feel that in many cases, possibly it will be useful for the state agencies for targeting the correct people, but in other cases there's potential of misuse also.
Thank you, sir. But there are also provisions which have helped the accused also.
Yeah.
Alternatives to alternative punishments have been prescribed.
Yes.
Community service has been introduced as a punishment for the first time.
Yeah, it has been.
And what are your views on that?
See, the reformative side, I'll share one anecdote with you that I used to see, especially at Chandigarh when I was holding trials, that there would be petty theft cases that cycle chori kar di. So this cycle chore thing was such a thing that even I would say that some policeman in zeal to complete his cases or somewhat could have nabbed such a youngster or somewhat. So in those cases, the heart used to burn that a person is being tried for such petty offenses. So now if guilt is proved, if in case guilt is proved, then there is provision for giving him the opportunity of reforming himself rather than having that retributive thing, that eye for an eye thing that we used to have. So we have that provision that he has to reform himself, has to do community service. And conversely, there used to be gangs of cycle thieves as well. For that thing, there is petty organized crimes. They have been covered. So that part I have seen that is a wonderful exercise of legislation that we have seen. But there is certain vagueness aspect as well. If we see the terrorism provision, the economic part, that the word has been used that economic stability is being hurt or so. So it can be, even a Heidenberg report can be termed at some point of time that it was hurting the financial stability of India, so it was a terrorist act. So the vagueness, I would say, a criminal statute that has to go away with the vagueness part. We have to be very specific, because the thing is, we are playing with the life and liberty of a person. Organized crimes, it has been used so much in a vague sense that we would say that earlier we have seen in the hinterlands that some 5 people or 6 people go for taking possession of their land. So that is also covered into that organized crime. If a person goes to take possession of his land, so such vague application of law and giving such a big playground for the policeman to do anything, that is, I would say that specific intent should be there, that these provisions should be specified and they need to be reformed further. Because on one side we have seen some beautiful provision has also come, but the draconian part, as my friend said, that has been expanded to such an extent that it is that I would say that it will be a brooding ground for corruption.
Also, my question to you on this point would be, you've served on the bench. You say that this gives us a chance to ensure what was essentially the purpose of law, to reform a person. The idea is not to punish, the idea is to reform an individual, to reintroduce that person into the society, right?
Yes.
So the community service in that regard, do you think that would be a stepping stone towards that one? And how does a judicial officer in that regard use that discretion to implement that punishment?
See, sometimes I have seen, when I was presiding over as a magistrate, that for example, some person who in a zeal to go abroad or to have his visa or something, he may have done something wrong that may amount to cheating as well. But the intent behind that was also to be seen. That was never to cheat any public authority. That was never a purpose that any individual person is to be cheated. There were some times that clerical errors could have also been there. Because agents fill up the forms when the students, they apply for the visas, or whenever they apply for the passports, it is the agents who apply for the same. In one such case, I had seen that if reformative provisions would have been there, then it would have been better. So we have something of sorts here. But on other side, I would say that we had Probation of Offenders Act, and the Probation of Offenders Act is one notch better. Why? Because once there is probation against an accused or convict, I would say, the effect of conviction is not there.
The stigma goes.
So the gray area would be that whether this community service would have that ameliorative provision as that of Probation of Offenders Act. And there is another thing, that even lesser than that, we had another provision that was for the purpose of chastising that person. Even the presiding officer would have said that you should not do that work again. That is also part of the Probation of Offenders Act.
To admonish the
admonishment, that is in so many words I had said that a specific term would be admonishment, but the thing is that this community service is a good thing that has happened, but with that, they should be that this thing should have the effect of what we had in Probation of Offenders Act, that the stigma of a conviction also goes. So that will reform that person rather than having him have the stigma for the entire life.
So wipe out the criminal antecedents of a person if the person has shown chances of remorse or for rehabilitation.
Yes. Because we have to feel the reformative winds as of now, at least when we are in this century, and we would say that we have gone away with the barbarian instincts of ours. So the reformative part should be given more weightage. And personally saying, if a person will still have a stigma after doing community service, there is no reformation itself. The reformation, it should not only be the reformation of that person, it should be the reformation of that person in the records as well.
Thank you, sir.
In fact, you're right. Some of these elements which are already there in the JJ Act,
Yes.
those could also have been introduced. In fact, a very famous lawyer from Andhra Pradesh, K.G. Kannavaran, used to say that the law determines the offence, but the state determines the offender.
Yes.
So the law has determined the offence very well, but who the offender will be, I think a very wide margin and scope has been given. And as so I was saying that it is the language of criminal law which has to be so strictly interpreted. There is no scope for vagueness. But if you have vague terms as economic terrorism and other things,
Everybody can be an offender.
yeah, anyone can be an offender. If you look at section 69, you can pick up anyone, any boyfriend, girlfriend, you pick them up, you target the boyfriend and you put him in jail. We've had those cases in many states. It is a 21st century law must have 21st century values.
Yes.
And those 21st century values can't be the same values as 1860. It has to be reformatory. You could have questioned many kinds of punishments. I would say even death penalty could have been questioned in many cases. You could have had graded punishments. Those things could have been done. Many offences could have been removed and many could have been even added. You have criminal offences in every small act, state act or central act. Why could you not have taken an exercise, a comprehensive exercise, to remove the criminal offences in others? For example, many countries, for example, Canada has a very comprehensive criminal code, and that criminal code contains all offences, or pretty much every single offence which will be committed will be there. Why do you need a separate act for PMLA, for example? Why couldn't you have economic offences as part of IPC itself? Therefore, Section 45 of PMLA could have been gone. So that sort of creativity, I believe, was lacking, but it's a good start. You could build on this.
So apart from the reformative side of justice, I believe the BNS has also done a lot for the restorative part. Of course, there's a lot that still needs to be done by way of us having a proper victim compensation scheme. So the restorative part, for example, I've been going through for sexual offences. Now it clarifies that the compensation, the fine, which has to be paid, is given to the victim. It has to be enough to rehabilitate the victim. So those kind of things, I think, will also go a long way in restoration, in giving us a sense of restoration to the victims of the crime. So I think those should be the two. That should be the idea behind any criminal code. It should be reformative and restorative, even for the victim.
So in a sense, justice should not, the ideal justice should be done to the victim as well, right?
Yes, because what happens inside the court is only one form of justice. But what happens to the victim outside in their lives, I think that is where restorative justice would play a greater part.
For that, the new act has included the higher compensation to the victims, right? So that part,
I think that is important. So, for example, under the Prevention of Atrocities Against Scheduled Castes, there is a very comprehensive victim compensation scheme. I believe something like that could also have been done for other classes of offences.
And there,
That is a missed opportunity, I feel.
and there the amounts are ranged to a few lakhs. Here the fines have only been raised to 10,000. And if you look at the sections, it will be interesting. The alternative punishment is either 1 year of punishment or 10,000. So ideally, even if we go by, say, someone is a minimum wager and he is losing, say, 15,000 rupees a month, he is losing. So at least for a year, your fine ought to be 180. It should be commensurate. And the idea is to declog the prison system also. So if you, instead of putting someone in for 1 year, you say, okay, there'll be a fine of rupees 2.5 lakhs. And of course, in appropriate cases, not where people can give 2.5 and say, okay, I'm free ho gaya. Not in those cases. But if you do that, there'll be many genuine cases where punishment will also be felt. At the same time, you'll declog the penal system and thereby, having less pressure. Only the serious offenders will go there. But, the topic is generally crafting litigation. Yeah. I kept thinking, as a criminal lawyer, I think this is a great opportunity for all of us who want to practice criminal law or who already practice criminal law. Because after 1950, you had a burst of constitutional litigation, tax litigation, etc. You had high courts and 226, and people made their careers out of it. I somehow feel that even BNS and BNSS, the vague wordings, the broad applications, and the manner it will be interpreted will be a contested space where all of us will be participants and hopefully be paid by our clients also for that purpose.
That is the important aspect of it.
That minimum punishment part that my friend was saying. For example, for the attempt to murder that we say that 5 years minimum imprisonment. Say for example, one person, he shoots in the air, but somehow the prosecution is able to prove that it was a case of attempt to murder. There the discretion goes from the judge. That is why the penology was there, that all the things, all the circumstances have to be seen by the judge while giving the sentence. Now taking away that discretion is also bad. And moreover, we'll see that for the grievous hurt that were done by the blunt trauma, there used to be bailable offences suggested for that. The offence was bailable. The earlier 325 was a bailable offence. And that of 324 was again a bailable offence. So 324 was a simple hurt with a sharp-edged weapon, but compartmentalizing that in the same bracket and getting it to be in the non-bailable bracket is also bad in law. I would say that though I'll be getting more cases here in the High Court for the anticipatory bails, and I have seen them get dismissed as well. But still, I will say that was bad legislation. And I'll humbly say so. That because the causing of grievous hurt by blunt trauma and that of by a sharp-edged weapon are two different things. They should not have been done in the same enactment.
The discretion should have been there.
Yes, should have been.
So mandatory minimum in any case are worldwide. There is a lot of criticism whenever you say, for example, NDPS minimum 10 years, you go. Right? There is a huge criticism because between one offender and the other, there can be a huge difference as to how someone is caught, in what circumstances, what was the history background. If you take that out, your judicial officers, sessions judges, magistrates, you basically have made them into postmen, where the police files something and ultimately they have to just decide whether guilty or not, and then the punishment is out of their hand, and that makes also difference. One good thing in this vis-a-vis Punjab, Haryana will be, there was an offence of snatching and snatching which hurt, which were both inserted in Punjab, Haryana and Chandigarh by way of later amendments, which was approved by the Honourable, His Excellency the President. Now, those used to provide a mandatory minimum of 5 years, only snatching, and 10 years with hurt, right? What used to happen in Punjab, Haryana is a simple theft case used to become a snatching case. 5 saal jana andar, right? One. Second, any case where people are fighting, they'll say, iske जेब में एक पेन था 1,000 रुपए का या 500 रुपए का 200 रुपए का, उसने उसको खींच लिया, and it used to become a snatching case, thereby triable by the Sessions Court, and no bail could have been granted in 5 years minimum. That luckily they have removed it, modified it. Now, of course, snatching is an offense across the country, but the maximum punishment is only 3 years. So that is luckily one place I thought they've removed the mandatory minimum. That was a good exercise of power. But otherwise, mandatory minimum in itself takes away the discretion, which is very problematic.
Building on what was being discussed earlier on the part of community service, the idea of plea bargaining and the mediation that has been introduced by the new act of BNS, like it's been propounded even further, that could also be one of the places where the litigation goes down, and if a person, that would take away the pendency of cases, and also, as sir had pointed out, the jails which are already overburdened, that could also see reduction in number, right?
I would say that reformatory part that I have always felt, that I have seen people reform. That is a personal side of mine that I have seen. That I have seen persons evolve from that of addicts to that of very good saintly people. Because it's the reform of a human being that is necessary at this point of time. We, even as law students, we had been reading that in criminology, we all had passed that exam of criminology, and we had that reformative justice. But when we see, even at the time of bails, my friends are able he has been an able prosecutor, and she is. And we have seen that even at the time of bails, we are not contemplating that part, that once a person goes to jail, that reformation part is gone. A person goes to jail. There are persons who may have been victimized by the police. They are also there, and many would have become Kabir Singh. And by the time he also gets out, then he is Kabir Singh too. And maybe a Gabbar is back. So these things we have to see. That reformative part should have been contemplated even further by the legislators. Because if we are legislating something after 164 years, 163 years, and it comes out half-baked, so if you are hungry and something that comes half-baked to you, you would say that it is not. This is injustice.
I think that's how senior advocate Rebecca John had described this entire exercise, that it's only merely old wine in a new bottle, which is, I think,
And
the most major criticism of these new laws.
Old wine that has been over-fermented, and that too had not been kept at optimal temperatures.
Now, sometimes
A lover would know that.
sometimes I often say, on the lighter side, that any room of lawyers I sit in, if we had given these people 6 months, all of us, like this room of lawyers, and these 3 acts, I think we could have come up with a better version.
At least the BNS part.
At least the BNS part, because there's inspiration everywhere. I mean, our constitution was inspired by the ideals of the best. It inspired South African and other constitutions. Our penal code inspired, or whatever, was copied across Africa. Most UK colonies, British colonies have a version of our laws. Like even South Asia, Pakistan, Bangladesh have a version. So we could have been the first in this. And if, say, the British in the UK could have reformed their, I think 1963 is when they'd taken a major reform. They removed death penalty, they've done other things. So it's been 50, 60 years. We could have done that sort of exercise. But the good thing is now this tells us that nothing is sacrosanct. Everything can be debated, and if something needs to be removed, either through the courts or through the legislature, it will be.
See, one another thing that I would like to say is that removal of 377, it altogether would show that the framers were oblivious of the reality that is happening around. It's not that only females would have been victims of the sexual offences. It can be males could have been. As I would say that in jails, that can be rampant as well. And we have seen as prosecutors as well as lawyers, we have seen that such offences are so rampant in jails. And I would say that in some of the places, these are in some of the backward places as well, these have been so rampant in offences That part altogether been missing from the statute is, I would say, that is oblivion about the reality.
Yes, I think going further on that, in fact, one of the objects or the stated objects of bringing in these laws was to bring in an element of gender neutrality when it comes to offences, especially when it comes to sexual offences. And that is entirely missing when it comes to who the victims of these offences will be. Even for the offenders, most sexual offences still talk about a man being the offender and a woman being the victim. I think that is also an opportunity missed, one. And the second is when it comes to homosexuality. So in that case, removing 377 altogether. So once the Supreme Court decriminalized it, but non-consensual homosexual acts should have been retained as an offense. So it basically leaves no safeguard for people who are victimized or, under homosexual acts which are non-consensual. There's no safeguard. Men who are victimized, there's no safeguard. And when it comes to offenders, only men have been retained in most sexual offences, which is, of course, a large part of the cases. But I feel that we could also have, like you said, moved into the new times, moved into the 21st century by keeping alive social realities.
Two offences, luckily, the offender is now, could be whoever. I think 354, yes.
Voyeurism.
So that is interesting. At least there, those restrictions have been made. So that's quite interesting.
I would also like to add the term transgender has been defined under these definitions. Under Section 2, Clause 10, transgender is defined. But nowhere in the Act pertaining to sexual offences does a transgender find the place either as a victim or as an offender. Moreover, as sir has already said, the Section 377 should not have been done away with in totality. There could be victims of the homosexual acts, like non-consensual part of it. Also, that would bring me to another question.
Transgender would be covered in whoever.
Will be covered in whoever.
He or she is not a necessity. Whoever would include the transgender.
Okay.
A transgender has not been used in so many words in
the Act.
in those provisions, but whoever covers them.
But that still does not serve the purpose, I would believe.
Yes,
Vagueness should not be there. Once we are defining an act, as you have said, after such a long period of time, so the vagueness could have been taken away with. Also, I would like to point out, sir had said some acts were taken away. Sedition is one of those acts. Section 124A was taken away and it was added again under the guise of other provisions. So I would like one of you to please take the mic and explain on that.
I believe Arjun.
Yes.
Fine.
Yeah. So,
Go ahead.
So, as far as sedition is concerned, what the conceptual thing that they have come up with is that they have done away with Rajdro. That government can be criticized, but they have come with the thing that Deshdro is not allowed. That it should not be a thing that undermines the state in its yes, sovereignty of the state, that is specific. But the thing is that the governance and the healthy criticism, or even if there is criticism as it is, the criticism is allowed against the government, but whatever undermines the state is not allowed.
But if you let's look at Section 152. There are two safeguards I think they've built in this, which is great. For example, the explanation. The explanation says, comments expressing disapprobation of the measures or administrator or other action of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section do not constitute an offence under this section. Very well. But tomorrow, if Karnesh is tomorrow, there's an FIR under Section 152, the local Thanedar won't be relying on this. And it's only when he gets bail, or his bail proceedings are going on, the same judgments which used to apply on Sedition, which said that if no violence has been inspired by your statements, there is no offense, that would have been good enough. So at this stage, retaining of this section, I don't feel it's good. I mean, there's still a lot of scope for manipulation, false imprisonment, and false FIRs. That's one. Second, they've added one more section where even so-called fake news or spreading fake information has now become an offense. So and the trouble with this is, notwithstanding who's in power, anyone who has the power to misuse a criminal section will do it. Invariably, that's how the power tends to corrupt whosoever is wielding it. And that is my biggest problem, that your criminal act or your penal code should be so strictly and should be so strictly measured or drafted that there should be no provision which can be used by the local police in this manner, especially when the BNSS still retains those wide powers of arrest and detention and others. In fact, if you look at, say, for example, section 172 of BNSS, we are only talking about BNS, but section 172 of BNSS says that if the lawful directions of any police officers are not followed, the police officer can detain me for up to 24 hours. What does that mean? You have given the constitutional powers of detention under Article 22, which used to be you had to give reasons, etc. For petty things, police officers can detain you just like that for 24 hours or 23 hours, 59 minutes, 59 seconds. And this is a strange power which could not have been granted. And this is something which will be coming up, hopefully, for a constitutional review. There are people who are preparing petitions to challenge those offences. And some thought will have to be given to that as well.
Thank you, sir. We have to discuss the diversity again for the protection of the women and children that has been envisaged in this act, in addition to the other acts which were already there, such as POCSO and the other acts. Can you please propound on that?
No, I think I've already spoken on this when it comes to women. But also when it comes to children, I believe they've made the provisions stricter when it comes to cyber stalking or use of, again, false information on the internet, child pornography. And also when it comes to the provision of gang rape for minors, against minors, I believe the distinctions, those age slabs that were earlier there in the IPC have been done away with completely. And now there's a mandatory sentence of either life imprisonment or death for all cases of gang rape with any woman under the age of 18 years. So I believe that way there is a move for greater protection of women and children under the BNS, but again, that again begs the question whether you support mandatory minimum sentences, because they're always open to misuse, and also take away the discretion of judicial officers and leave them open to further appeals and going to higher courts, which might work well for lawyers, but of course does not work so well for even for the accused.
If anyone could please take on the aspect of cyberbullying further and the advent of artificial intelligence and how it is being used to manipulate children and those who are vulnerable sections of the society.
I had been wondering one day that whenever we used to decide cases, exhibits or photographs, we would say that this and this is exhibited in the photograph. And we would say that on the basis of this, it has been corroborated that such and such accident had taken place in such manner. So if we get something AI generated, or we get an exhibit that is not totally not proved as per the provisions of the Sakshi Adhiniyam, and a bail, even if a bail is decided upon that, we will say that the exhibit of document will be as per the mode of proof. But if the photograph is shown to the judge at the time of when the bail petition is being decided, the chances are that a person can be swayed away. And so is the cyberbullying as well. That someone sends you a photograph that you are stealing this thing from somebody's house and would say that will further exploit you. can exploit you. And I would say that it's high time that there should be a mechanism that the pictures, whether they are superimposed and the deep fakes things, if AI is there to make those deepfakes, the AI should be there to detect that whether it is AI generated or not. So that aspect is also to be seen. And if someone comes up with a technology to safeguard the same, I would say that that unicorn thing would work up with billions, because that will be safeguarding the reverse victims. Reverse victims, I am saying the accused who are victims themselves. And the second aspect that you were saying, I have not touched that aspect.
Like children are being exploited.
Yes.
Due to the AI also, due to cyberbullying.
Cyberbullying aspect we have touched.
Those will be in any case covered in
Yes,
POCSO.
POCSO, yes.
Those offences, I think.
Those have been added over the provisions of the new BNS Act. Again, recognizes it. That is another aspect that we have to see, that things that were already predefined in other acts, they have found their places again in BNS. One, what was the need to bring it under BNS? Second, what purpose does it solve? Bringing it back under a general code.
See, I'll pass on the mic to my learned friend, but while I was going through the provisions themselves, I was wondering that we had grown up with the thing that the special statutes are to be taken as to be the ruling one, and the general statutes will not be covered to be the ruling one. Yeah. So generally are specially based non-derogant, so that the general statute cannot derogate against. Now the general statute has been made derogating against the special statutes. So I don't know that what wisdom was there by which the general statute, general provisions, and that too vaguely worded have been made, so that they can be brooding grounds for false criminalization of persons. Because what we have to see that it is not about the strict interpretation of criminal laws. It is that the criminal laws have to be strictly worded as well. Interpretation comes afterwards. So giving so much of mother-like statements and wordings would mean that we have another 2-3 years, we will see that there have been multiplicity of the criminalization rather than multiplicity of litigations that we see in the civil side. In here, there will be multiplicity of implications because of the vagueness of the statute.
And I think it will happen both ways. You have given discretion to the concerned police officer to choose either a special act with its safeguards, special courts, sanction provisions, etc., special bail provisions. Bereft of all of that, you put it in a general act and you say this is also an offense, right? This means, so tomorrow, for example, we'd spoken about terrorism. Similarly, in many other cases, things which were not an offense have become an offense. This leads to what is known as the over-criminalization of society. Jahan pe aap something which was not an offense suddenly becomes an offense. The entire structure which was built, structure of POCSO, structure of UAPA, you have special courts, you have an entire series of judgments to deal with that. Either you set those aside, you say, this will be part of the general criminal law. Because the reason you have an entire special structure is, the reason, for example, you have presumptions under section 2930 of the POCSO, you have presumptions under section 43, 45 of 44 of the UAPA. You have these because these sections have been worded in such a way that almost anyone can become accused in these cases, right? You want to keep these offenses away from the general criminal law because you don't want the same court or the same judge to decide it without those protections. For example, a witness in the case of POCSO, how a witness is to be treated, how a victim is to be treated, they are all defined. They have multiple protections built in. If you don't have the same protections built in BNSS and BNS, how will that trial progress? And this creates a huge problem. There is a presumption of law in UAPA. If someone is caught with a weapon, they'll be presumed that they have committed the offense. Now, what do you do if you are not under UAPA but under BNS? So even for the state, it will be a big issue that maybe that will lead to someone who is genuinely a terrorist, who is prosecuted under BNS, might just be acquitted only because those protections which the state was getting or the prosecution agencies was getting. I say this as a former PP, as a former DAG. Those create huge issues because people will start getting bails. On the other hand, if you are wrongly accused, you would rather be in BNS than be under POCSO or UAP or the other offences. So you have to really think about it and take a call that either you abolish these special acts, make it part of the general law, or you have a separation.
Like last topic that we'll be dealing with is new crimes that have been defined, especially hit and run under section 106 and mob lynching under section 103 and 104. Your views on that, then we'll open the house to the public to ask their questions.
As far as mob lynching is concerned, Tehseen Pune wala judgment had already come on that, and that has been incorporated in the form of a statute. And I would say that it is a commendable thing that nobody should be lynched for the purpose of the religion or the region or the caste or any race of his is because he is being penalized and mob lynched for the purpose that he belongs to some other caste or religion or region for that matter. But that hit and run provision, that we would say that it has not come into effect. Yes, that hit and run part, the subsection 2 has not come into effect.
No, but I'd like to say something
Yes.
about both of these.
Yes.
So, interestingly, you look at 103, which deals with so-called mob lynching. It says group of 5 or more persons acting in concert commits a murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground. Each member of this group will be liable. Now, this, in any case, I have a different view about it. Even under IPC, if someone did commit what is called as a mob lynching, or a group of persons on this basis killed someone, there was punishment even there. Of course, what used to happen, we've dealt with several of those cases, was they used to say, isne mara. The one person used to be targeted, he used to become the main accused, and the other used to be acquitted or convicted for lesser offences. So probably that this covers it. But I have a feeling that there is a certain vagueness in which they have drafted this subsection 2 to 103. And then you'll have to see that, A, were they acting in concert? Were they doing this murder on the basis of race, caste, communities, so on and so forth? Or similar ground. What does similar ground mean? Can you add another ground? I don't know. If, say, 5 policemen murder a bystander, is that my mob lynching? I don't know. I mean, these things will come up, and these trials, when these questions are asked in trials and in appeals, either people will be acquitted only on the basis of this, or you'll have many convictions on the basis of this. The if you look at death by negligence, I mean, I don't know what his view is, being someone who's probably been part of convictions on the basis of death by negligence, accident cases, etc. And acquittals also, thank you for that. But I don't know why you need a special provision only for doctors. So doctor karega to 2 saal ki saza hai. But anyone else does it, if anyone else does it, it can go up to 10 years, which has not been brought in. And imagine the plight of even the accused. Today he is being charged with an offence which is bailable, punishable only by 2 years. And that man today, if this provision had come in 106(2), he would be charged with suddenly 10 years for the same very offence. We have to ask ourselves as a society that accidents happen, even to the best of people, in the best of circumstances. Mistakes are made. And unfortunate deaths happen. But do you want to put people in for a mandatory up to 10 years for that? And if this is 10 years, that means he won't get anticipatory also. He'll be fighting for a year or so for regular bail. How do you deal with that aspect?
That takes away what we began with, the community service and the reformative part. That goes away with this. Like we've come a whole circle from reformative again to retributive. I'll open the house to the public.
So if a person does not run away, if a person does not run away and stays there and is himself killed due to the mob lynching instead. that they want, and they don't want that a person should escape. Sometimes accidents do happen, as my friend said. Accidents do happen, but it doesn't mean that that is why it's an accident. Had it been due to some intention,
Intention and knowledge aspect of it goes.
so keeping it as culpable as a 304 as earlier had been, and making 304A akin to 304, it's irrational, I would say.
Ma'am, your question?
So we talked about section 69 of BNS and decriminalization of section 377 of IPC. So of these two sections, I have used like why in the modern area as well, we feel that the woman should, why it is so easy to say that a woman have to be a slave of the husband. There could be a chances that woman is not interested, but she could not file a case because 377 is decriminalized. Secondly, section 69, why don't we focus on written, agreement or something like that? Rather, we focus on if someone, cheat due to some circumstances and we are sending him 10 years, jail and something like that. But why don't we focus on the written agreements of the relationship? If one guy is having 40 relationships or 100 relationships, why it should not be exposed to the society? Why a woman should be fooled by a person? There should be amendment. सजा के साल बढ़ाने से अच्छा है कि हम उसको practical कोई approach उस पे रखें. That is my view on that.
At the same time, you also have to look into the fundamental right to privacy. You're saying that there should be a written agreement where they should disclose their relationships. I think that is exactly what the Uttarakhand government is. Yes. Exactly. So, that is exactly what the greatest issue with the UCC in Uttarakhand now stands. That you have to fill in a 16-page form also disclosing your past relationships. And who is to say how truthful those disclosures are, after all? I mean, if somebody has to use deceitful means, they're not going to write down the truth.
See, एक कहावत थी कि वहम का इलाज लोकुमान हकीम था. That was the biggest हकीम that we had. उसका इलाज किसी के पास में नहीं था. अगर कोई वहम का मारा आ गया या आ गई, तो where will that person go? नहीं, that is not, indeed we are not saying, but we have to see that reverse victimization, as we were discussing, that reverse victimization should also not be there. That accused should not be, because someone who is not an accused in reality is not reverse victimized. That is also because the laws are not only to be strictly worded, they have to be strictly interpreted. Strict doesn't mean that we have to flog him. Strict means that whatsoever has been written in the statute, that has to be adhered to. No, nothing inflaming or accentuating that language. That is why we say that there should be nothing. But because if we incorporate such a provision, that will be adding on to the vagueness that we were addressing to. नहीं, यहाँ तो नारी शक्ति भी खत्म करती, नर के पास भी 377 नहीं है यहाँ.
If in fact let's look at 69. It's very interestingly worded, and it is gender neutral in terms of the accused. Okay, let's look at it. Whoever, by deceitful means or by making promise to marry a person without any intention of fulfilling the same, has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape. Now, I don't know how that will work, because in any case, rape has been very broadly interpreted after 2013, shall be punished with an imprisonment of either description for a term which may extend to 10 years. And now explanation says, deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. The way they've interpreted this, you say not amounting to offense of rape. So what is sexual intercourse not amounting to offense of rape? That's one. Second, what do you mean by things like marrying by suppressing identity? The suppressing identity itself is such a broadly defined word. Tomorrow, if I don't tell my prospective wife that I am also am member of a certain organization,
or was a prosecutor.
Or whatever. Or I'm a lawyer. It's also part of my identity, right?
Consider for a minute, you say you don't discover that you're a Mongolian.
Whatever. Correct. Yes, absolutely. I mean, these are all things, and punishing it by 10 years, which makes sure you don't get bail. These will be criminalized, and these will open up Pandora's boxes, which will clog the system again. And this is something where thought ought to, and I understand your point when you say written agreements which become the basis of, you say that every relationship, there should be a written basis of that.
हाईकोर्ट की जजमेंट है कि ना जिंदगी जो ट्रस्ट में चलती है सर हमने ट्रस्ट कर लिया अगला धोखा
No, you are right. Ma'am, question is कि trust कर लिया, but does everything have to become an offense? Could it be a civil wrong? Can I file a case, maybe a civil suit, saying that you have entered into this relationship with me, you pay me 5 lakh rupees, instead of saying you put that person in for jail for 10 years? So we as a society have to have a conversation about it.
I think that's it. One question.
One question is that as the panelists have discussed about reformist and restoration measures in the criminal law, can anyone imagine, apart from the criminal, what are the other measures available in the society?
Apart from criminalization?
Apart from the criminal laws, what other measures are available?
For example, you have a domestic violence. I'll give you an example. Domestic violence can be punished as assault, but we also have an act which provides civil law remedies. You have an entire structure. It may or may not be working, it's a different matter, but today if someone has a issue of domestic violence, they can go to the appropriate court and there'll be compensation, etc., that can be given. You could have you don't have to criminalize everything, because the problem with criminalization is everyone ends up in jail. You don't have to send everyone to jail. And there'll be, in domestic violence, there used to be many cases where the wife would say, "Mere mard ko jail na bhejo," but punish him somehow. Right? There are cases like that. Similarly, in this section 69, you have to ask yourself a question: do you want to send that person for jail for 10 years, or could we as a society think of a creative way of punishing that person, reforming that person, and doing something? And there, across the world, in UK, EU, there have been laws which, without sending people to jail, can reform a person or penalize a person. So that exercise can be done.
I would say that we have to see what offence is also alleged. For example, if we see that if a policeman is holding something for checking the alcohol, they are using an instrument and he is having a Red Bull and it's showing that it's alcohol. Should we punish him and send him behind bars, or should suspend his license and use everything behind him? Otherwise, the thing is that there are chances, I have seen as a magistrate as well, there have been instances that the instrument that was being used by the policeman was false. Because the person was vigilant enough to go to the hospital immediately and get his blood test done, and that there was nothing of alcohol. And we can even judge from the gestures from that person that he didn't even ever touch alcohol. So reformative justice, even for the person who was a drunkard, who had misbehaved in society because of the drinks, maybe he had gone one drink up than what he used to have, and he misbehaved in the society, he misbehaved in the marriage function, had been unruly. Should we send that person behind bars? We have to see the offense that he has committed. It's not that for murder, we are saying that he reform him by giving him community service. It's not our thing. We have to see the offense as well.
What is the bar of punishment in this? And the conditions for the bail?
Which bar? Are you talking about the bar of?
The bar of punishment. Like for example,
I thought that we were talking about the drinks and you were
bar somehow related, but anyhow. Then what will be the bar of punishment? Like even if we're talking about, like one person, as he said, like one has taken one up drink than the other. So what is the bar of punishment? The community service itself is a vague definition.
It is a vague definition, I agree. Yes, and I think...
So we were talking about reformation, and sir was talking about somebody maybe stealing a bike, like a cycle.
Yeah.
He goes through the entire trial, and after the trial, if the judge says, oh, it's a petty crime, let him go for public service or whatever, that entire trial becomes redundant.
Yeah.
Instead, is it not better to have a
Plea
more
bargain.
robust plea bargaining
Yes.
system, wherein the prosecution and the defense can sit down and just talk, yeah, ठीक है, you do public service for 6 months or whatever, and that would take away, that would declog the judicial system, that would declog jails, because also most times these people can't afford bails because they can't afford decent lawyers and they rot in jails as
Yes.
trials.
For
This
that,
has to be a robust and a circular system. It has to be a
Absolutely.
comprehensive thing.
even for that part, if somebody confesses at the inception of the trial, there are provisions that he can be admonished or can be left for under probation of Offenders Act. It works as well. It works as well. It's not that I'm saying from something that is a wild goose, but I'm telling from experience that sometimes for the petty offences, the persons do confess. So there we have to see that whether we have to punish that. For example, having 2 bottles in the boot of the car, it's a normal thing for a Punjabi. So if he confesses that crime and he is under Excise Act, should we send him behind bars? The thing would have been. That is why I say that having that there should be minimum punishment for one offence. We have to see that where we are living. So had these 2 bottles been in Bihar, where prohibition law is there would have been no anticipatory if he would have run from the spot. I have seen one instance in this our court itself that one of the honorable judges was startled that there is anticipatory in the Excise Act has been filed. Then we had to tell that it is Punjab. So having 2 bottles is not a big crime here.
But I
So we
think
have to see the
you're
situation.
absolutely right. We need a rethink of sentencing. That sentencing has to include community service, which has to be properly defined. Not anything can be community service. It can't be because I am a judge, I like Karnesh's face or his family name. I say, Acha beta, you do this 24 hours and it's okay. But write an essay or whatever. And I say, oh, I don't like your face, I send you to jail for 3 years. And I like that person, I say 10,000 fine. Same punishment. 3 years punishment for one, 10,000 fine and community service. So that creates an unimaginable playground for judicial discretion or indiscretion. But we have to have that sort of a gradative sentencing system. Without I don't support the US sentencing system where they say if a person takes a weapon to a bank, then it will be different. If you take a automatic weapon, it will be a different thing. If 2 people going with automatic weapon and someone gets hurt, it will be a different thing. And you can calculate the number of years. I mean, that also creates a big problem.
The context is very different.
But plea bargaining, I think there should have been a much bigger push for something like this. And you are absolutely right. If someone is caught stealing a cycle and has to spend 20 days in court, they have to sit in court for 20 days. That itself is, I think, a punishment.
So, as in the statutes that going for the mediation aspect in the matrimonial statutes and other statutes, family statutes that I would say, that going for mediation has been made mandatory, that the plea bargaining, that once we can try for the plea bargaining, if not the mediation, because even in the compoundable offences, the mediation proceedings are done, even in the matrimonial offences it's done. If plea bargaining is also included as one of the necessary steps, that after framing of charges or before the framing of charges, yeah, it can be, it can. Yes, it is also there. The thing is that discretion, I would say, the judicial discretion. I've always said that judicial discretion should not be as an empire tosses the coin. It has to be judicially guided. That is why it is judicial discretion. It's not a discretion as arbitrary as some administrative person would have.
I would just say let's carry this discussion over coffee, because of the paucity of time. I'd also like to thank the Honorable Chief Justice once again, and we'd also be conducting one more seminar on the 21st Senior Advocate Mr. R.S. Chima would be conducting this. On confidence, on building confidence for lawyers, that is essential for all the young and budding lawyers. This would be conducted on the 21st. Once again, thank you everyone for sparing their time, and thank you all the esteemed panelists for making good that, thank you so much, and
Thank you,
Thank
Pradesh,
you.
and thank you, Madam Ahluwalia, for organizing this.